The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon. Welcome to another Ask the Experts, where we bring you the finest experts in the field of legal, health, financial, and home improvement. Boy, do we have a show today for you. I mean, this is going to be a knockout show. The subject matter is not the most, I would say, positive, but we're going to turn it into a positive. Because we have one of the most incredible tax relief attorneys, bankruptcy attorneys in probably the entire, I would say, area of Illinois, Florida, Texas. And I want to welcome, and I'm telling you, you want to sit back. If you got a friend that is having problems with the IRS, you want to get them watching the show today or listening to the show, because that's what we're going to be talking about for the entire 50 minutes of the show. Let me welcome Kevin Benjamin. Good afternoon, hey. Kevin.
How you doing?
I'm doing sort of good. We're having some technical difficulties here, but we're going to get it worked out. Kevin, you know, we're getting new listeners and viewers. It seems like daily. Tell people about yourself and your practice.
Okay, so I guess this is the bankruptcy half hour here. So I'm Kevin Benjamin Legal Services, and we're a full-service consumer and business law firm. Handle mostly debt relief, tax issues, and foreclosure. Most of our clients are consumers, though we do handle businesses as well. And we help people get out of debt or restructure their debt or save their property, stop foreclosure, IRS representation, resolving tax issues, and things of that nature. We've been doing that for over 30 years.
Kevin, it's not an embarrassment anymore to have to be in bankruptcy, is it?
No, it's never been an embarrassment. I mean, bankruptcy has been around for 100 years or more than that. You know what I'm saying? I think Benjamin Franklin, someone filed bankruptcy. Of course, Donald Trump did it several times, business-wise.
Yes.
Our country is based on a fresh start. So I'm not talking about the IRS Start Fresh or Fresh Start initiative. I'm talking about the bankruptcy fresh start. Okay, so we are a nation of basically entrepreneurs, small businesses, and the bankruptcy laws are designed to actually encourage people to take risks and try to get commerce and innovation and made us a great country. But if you can never get out of debt and have a debt prison, why would anybody want to start a business and borrow money and try to employ people, etc.? So you're only allowed, though, on a straight bankruptcy. There's different kinds of chapters we could discuss briefly. But when someone says they're filing bankruptcy, most people are talking about getting out of debt. So the fresh start, starting over, take your mulligan, your whatever you want to call it. It's a one-time every 8 years option. So you can clean your slate, but only every 8 years. So you can't just file a bankruptcy next year, go out and just borrow a lot of money and then file a bankruptcy. So you got to do some bankruptcy planning, because it's not always advantageous to file just because you're in debt. Depends on your situation. Maybe you got medical bills ongoing. You don't want to file now because you might want to include those things as well. Maybe you got taxes. We could talk about some debts can be discharged, some aren't, and there's different time frames. So, are we going to file now? You're going to file in 6 months. What's the benefit? There's also qualification income-wise, for example, in bankruptcy, and depending on it's the whole formula. I don't want to bore everybody with the formula, but it changes every month, depending on your income and how you're getting paid and that kind of stuff. So your qualifications maybe you don't qualify now, but you qualify in a month. So that's what you have a lawyer for. The consultations are usually free. There's other kinds of chapters of bankruptcy. It's not just getting out of debt. So to answer your question, there's no stigma, by the way. I mean, it's a fresh start. You're out of debt and you're starting over. People got jobs and you feed your family and you move on. Also, there's other kinds of chapters of bankruptcy, which are not getting out of debt or partially getting out of debt. For example, there's all kinds of chapters. So Chapter 9 is for governments. Chapter 12 is for farmers. Chapter 15 is like cross-border. Chapter 11 is a corporation restructuring or a more complicated individual. An individual can do it, sometimes has to, but that's rare, okay? Generally speaking, for a consumer, it's Chapter 7 or Chapter 13. Chapter 7, it's a straight bankruptcy. I'm getting out of debt, starting over every 8 years. Some debts aren't discharged, some debts are. I'll go about that in a second. Chapter 13, think about it more of a personal bill consolidation or court-ordered bill consolidation, interest-free, that actually works. The way a corporation stays in business and restructures their debt, a person can do it in Chapter 13. It's just cheaper, more affordable, but you're also limited to 60 months. Now, in a Chapter 13, you don't always have to pay back all your debts. Sometimes you pay back some debts in full and some debts less than full. That's why you have an attorney to talk about different kinds of debts. But you keep all your assets. It doesn't matter if you're making money and you could pay more. It doesn't matter. You get the relief. Generally, it's used for foreclosures. People stop a foreclosure, get behind on your mortgage. The bank's foreclosing. They want all the money up front to catch up, to cure, or they're taking your house. File Chapter 13, stops the foreclosure, and you get 5 years to cure the arrears, not 1 month. So it's pretty straightforward. People do it to stop a car from being repossessed, or if a car was taken, to get it back, stop wage garnishments. Some debts are discharged in 13s and aren't discharged in 7s. It's called a super discharge. But getting back to Chapter 7, so you have your secured debts and your unsecured debts, right? So what happens is on secured debt, like a car or a mortgage, you have the option of keeping it and paying for it or giving it back and owing nothing. Then you have your unsecured debts that are two categories, priority and non-priority. Make a long story short, some priority debts may have to be paid in full, like maybe a child support order, something like that. Generally, unsecured debts, credit cards, medical bills, loans, they're just discharged. Student loans generally are not, but there's a whole U.S. trustee program now that you could actually, people can start getting out of these student loans as well. But they would be categorized as a general unsecured debt, and you just pay back. You have exemptions, so you keep all your assets. It's federal law, but state exemptions. So most people don't lose anything in Chapter 7 because that's why you talk to a lawyer first to make sure you're not going to lose anything that you don't want to lose. Maybe you want to give the car back. You know what I'm saying? Maybe you don't. You can keep it. So then, let's say you have a mortgage payment or a car payment. You want to restructure it and try to get it lower. That would be a Chapter 13. There are exceptions to that. It's called a cram down. That's why you have a lawyer. Give us a call if that's the case. We'll do a free consultation on how you could maybe restructure your car payment or even your mortgage payment if you are exempt from what they call the anti-modification provision. I don't want to bore everybody with the legalities of stuff on there, but there's all kinds of ways to fix your situations in different chapters of bankruptcy, and there's no stigma. This is what the code is for. This is what Congress gave everyone the power to do, either get out of debt or restructure, the same as the corporation does. So there's no stigma at all.
You've gotten several
text messages, which I'm looking at right now, and people want to know, do you guide your clients on whether they should do a 7 or a Chapter 13?
Yes. Yeah, that's why people call for consultation. As a matter of fact, sometimes people call, they want a Chapter 11, but they think, they don't know what it is. They really need a 7 or a 13. So people are in debt, they're stressed out. You call me, okay? Most lawyers do different chapters. Not all of them do, quite frankly. Some people only do 7s or 13s, and you don't want those kind of guys. You want someone like myself, and there's others like me who understand all the chapters of bankruptcy. Because tell me your situation.
Can you hear me? Can you hear me?
Can I hear you? Yes. Can you hear me?
Yes.
Can you hear me?
I can.
So, okay. I'm sorry. I wasn't sure you heard me. What was I saying? I thought we had some technical problems.
Well, we're getting a lot of text.
Oh yeah. So
People
you
want
call
to
me.
know.
I'll explain things to you. You just tell me your situation. What are your debts? What's your assets? You're being sued, garnished, foreclosed. Tell me what's going on. Okay. That's my job. I'll figure it out. Because our job is to give you a free consultation, financial and debt, right? And then with our experience, to give you your option or options, tell you the pros and cons of each, quote you the fees of each, and help you make an informed decision of what you need to do. Part of that consultation of maybe you have more than one option. So we'll give you all the options if you have more than one. There's also that the bankruptcy planning and the exemption planning we're talking about before. And we'll start going over that and talking about if you're filing X chapter, are we good to go now, or are we going to do it in a month, or, depending on your situation. Everyone's situation is kind of different, actually. I'm saying. And then you being garnished, can I get the money back? All that kind of stuff. So all you do is give me all the information, and I'll give you all your options. I've been doing this over 30 years. I know how each chapter works and how it could benefit you or not. And if you got more than one option, I'll give you my opinion, but we'll do what you want to do. Sometimes you kind of do both. Now, there is no both, right? But sometimes in a Chapter 13, you could pay back some bills in full and some bills at pennies on the dollar, which is kind of like doing a 97% Chapter 7. And if you call me, I'll explain how that works if you qualify for that, because maybe you could qualify for Chapter 7, but you're in a car repo situation, or there's a different reason that you need a 13. So only got to pay back the bill that's in question in full, and then you can discharge the rest. So, I will give everyone their options.
What about student loans? Can you talk about those?
Yeah, so student loans generally are non-dischargeable, and for years it's been a nightmare. So back in the day, well, even before my time actually, you could discharge student loans. Then it was, you had to wait 5 years. Then I think it was 7 years or 9 before they made it, you can't do it. You couldn't discharge government loans, right? Then in 2005, they added, you can't discharge private loans, private student loans. Now, what's the difference? First of all, it's a scam, right? Why are there private student loans? Because they're jumping in the program, having the government try to ban them to get a free collection activity. The government student loan is a different story. That's taxpayer dollars, right? But also with the federal student loans, there's other programs to resolve a student loan problem outside of bankruptcy. There's, partial payments, sometimes zero payment, and there's forgiveness depending on different plans. So the federal loans are a lot easier to take care of, but the student loans never did that. The private ones, they just go to collection and sue you, and they have to, they lobby Congress, have them change the laws in 2005. We're not dischargeable either, and they're just taking your money. It's ridiculous, right? So now, if you wanted to discharge them in a bankruptcy, you got to file what's called an adversary proceeding, which is like a lawsuit, right? And you got to claim a hardship. And then, of course, it's federal law, but there's, it's different jurisdictions have these different tests. Like, Chicago area had this Bruner test thing, which no one ever got discharged because it was an impossible, ridiculous formula, right? So finally, the last couple of years, a lot of student loan things were on the law. Biden was trying to do things. So now the U.S. Trustee's Office has come out with some parameters, basically, to not challenge certain discharging of student loans. It's a whole application process now and a whole different ball game where if you have a competent student loan lawyer in conjunction with the bankruptcy, you got a good chance now to get that discharged. And it's too much to go over in a few minutes here right now. But the government has changed their tune a little bit. Now, there's an election coming up in another year. Depending on what happens, is it going to change back? Who knows? But right now, the political front is to have the U.S. trustee go along with more student loan discharges, and it's more lenient on the hardship. So yes, it's a good time to try to do it.
Hey, Kevin, we've got 1, 2, 3, 4 people here who wrote in a question about when you owe taxes, can you put those in bankruptcy?
Well, generally, I mean, first of all, yes, you have to put it in bankruptcy. When you file any chapter of bankruptcy, you must list all your assets and all your liabilities, whether they're discharged or not. Okay, so student loan, taxes, everything gets listed. Then the question becomes, what assets are exempt and what debts are discharged or not? Or is a creditor going to file a lawsuit, or the U.S. trustee, to ban your whole discharge for not disclosing everything or fraud or whatever? Or a creditor just saying that maybe my loan was bad because you gave me a false financial. They don't care about the rest of the case, but they want their debt discharged. Those are adversaries also. But now getting more to your question, yeah, you got to put it down. So it's dischargeable or it's not. Now, before we file the case, though, there's like a whole analysis on discharging taxes. So generally, they're not dischargeable, but sometimes they are. Okay, so it's a whole
what determines
formula,
that?
but basically they got to be 3 years old. The case had to been filed 2 years after the case taxes were filed. The assessments on taxes had to be at least 240 days. Filed in good faith. I mean, there's more parameters. But basically, when you have an IRS debt, right, oftentimes it's more than one tax year. So you may say I owe $50,000, but it could be one tax year, it's $50,000, we analyze it, but it could be 7, tax years. Saying it could be 12,000 and 8,000 and 6,000. So you got to break it down and do your analysis on each tax year of, is it dischargeable? And if so, yes, great. But if not, when? Because just because it's not dischargeable, it's going to be at some point, right? Most likely. So we'll analyze each tax year to say, okay, this part is if it's going to be discharged now, but if I wait 30 days, I could discharge another 10 grand, another 20 grand, maybe 9 months, maybe you don't have 9 months, so you're going to file in a month to get rid of most of it. So it's part of the planning, I'm saying. So you don't just file. Yes, you list it, but before we file, let's figure out, is it dischargeable or not? Because I don't want to file your case. You got, $50,000 or more, or 10, whatever it is in taxes, and I file your case now because you're in a hurry, right? But then if I would have waited 2 weeks, it would have been discharged. But now it's not, so that's not a good idea. So we have a whole analysis, and that's part of our job also, to analyze the taxes before you file as part of the BK planning and exemption. And that's why you have an attorney, because it's not just a matter of filling out forms when you file bankruptcy. People think just go online and fill out the form. You got to understand the exemptions, timing, analysis, exceptions. It's legal work, what I'm saying? So, and it's affordable too. So it's not like a lot of money to file bankruptcy. But yes, you got to list your taxes, but let's get them discharged if we can.
What happens if you're married? And I mean, just one of you have to file bankruptcy, or do both of you?
No, it's kind of like filing taxes. So when you file bankruptcy, you disclose, are you married, single, whatever you are, right? So you still disclose your status, and then you disclose filing jointly or filing individually. Filing tax returns, you file married, filing separate. Bankruptcy, married, filing jointly, great. Or married, filing separate. So let's say the husband is filing, he's the debtor. if the wife files, then she's a joint debtor, right? But if the husband files and the wife's not, the wife becomes the non-filing spouse. So she's not filing bankruptcy. Now, when you file bankruptcy, though, for your income wise and depending what chapter you're doing, all that kind of stuff, you still list your household budget, household income, household expenses. Like, for example, if one spouse is not filing and she has debts that she's liable for, whether they're co-debts or her own, she's not getting discharged. So maybe she's got credit card payments still and other payments still, and her income's going to that, because that's on the household budget. There's still some debt there. Okay. But also for the income, it's just a matter of, qualification on the Chapter 7, or if you're filing a Chapter 13, you're funding a plan, you simply propose a repayment of, say, 3 to 5 years, right? Interest free. And then that's great. You could get a Chapter 13 confirmed, but you have to have regular income or someone's helping you, and you got to have a budget showing you can make the payment. So let's say you're doing a Chapter 13 and it's $500 in 3 years, right? That's great. But if the income and budget shows you don't have $500, then it wouldn't get confirmed. So it's household income, but non-filing spouse is separate, and then it's not on her credit or anything like that, or the husband's credit, whoever's not filing.
What do you do when you own your home? Can bankruptcy keep you from losing your home?
Well, absolutely, because there's different kind of chapters. So first of all, like I said, it's federal law, state exemptions. So part of the consultation and bankruptcy analysis and bankruptcy planning is the exemption planning. It's federal law, state exemptions. Now, Illinois is not a great exemption state, and a lot of our BK groups and lobbying, Springfield and whatever, just politically trying to get these things to be normal. But for example, in Illinois, if you have equity in a house of $30,000 or less, it's exempt. You have a $30,000 exemption. Now they give you more. Let's say it's 40 or 50,000 in there because there's cost of sale, all that kind of stuff. But if you got 200,000 in equity, only 30,000, or if one of you files, it's 15,000, but then only half the income, half the equity is yours, so it's the same thing. So you got to make sure you could protect that. Cars though are usually underwater anyway, and you got a 4,000 wild card or 8,000 wild card if it's two people. So you got to make sure you're not going to lose the house. Also, how is the house being held? Is it tenancy in common, joint tenancy? There's different ways to hold title. Then you have your homestead. It's got to be your homestead if you live there, right, to have the exemption. But if it's tenancy by the entirety, which a lot of states don't have, but Illinois does, then it's 100%. So then if you got all the equity, then that's exempt. And then there's different issues of whether it's worthwhile doing or not, but you could have the whole exemption. Okay. Now, let's say you're in foreclosure, or you only owe $20,000, but you got all this equity in the house, and you don't want to take out a home equity line to pay off this stuff. When I could just do a Chapter 13 and keep the equity and just pay, in my example, the 20 grand over 3 or 5 years at 0% interest. I'm saying it's like getting a loan by filing. I'm saying so. You could simply cover your equity, or if you're in foreclosure and they're taking it, then it's not a 7, because a 7 is not going to help you. It's a 13 or an 11, most likely a 13. You do what's called a cure and maintain plan. You file bankruptcy and say, hey, starting next month, a month from filing, I'm going to start paying the current mortgage, and the bank has to take it. And then the arrearage, the default amount with attorney fees and interest, we'll go over that to make sure they're not, making the numbers up or garbage fees, that kind of stuff. But let's say it's, X thousands of dollars in arrears. You pay that over 60 months. So you make it's called a cure and maintain, but it's really maintain and cure. You make your current mortgage payment and like 1/60th of the arrears over 60 months. So it's the mortgage payment plus a little bit on the arrears every month, and they can't take your house, and that's it. So that's a very main purpose for Chapter 13 is keeping the houses.
Kevin, we've actually, your shows always go so fast. We've come through the first half of the show. We're going to be talking about tax relief now. But before we do that, Kevin, give everybody your phone number and your website.
Okay. 312-853-3100. That's 312-853-3100. You can email us at attorneys, plural, attorneys at benjaminlaw.com. The website's benjaminlaw.com. 312-853-3100. So we're based in the West Loop of Chicago, and give us a call, and the consultation's free. And you come in person, or we could do it on the phone or by Zoom.
Kevin, when people, this, when people get this envelope in the mail, it's got, it doesn't have 3 letters on it. It actually spells it out. Internal Revenue Service.
Right.
It's not funny, but people don't open them. They stick them in the drawer, and they think they're going to disappear in that drawer. It doesn't work that way, does it?
Yeah, that is actually same in bankruptcy. People they come with a pile of bills. I'll open it. You know what I'm saying? And the problem is, if you're being sued or in foreclosure, you don't know what's going on because it's so stressful. It's emotional. So you don't really know what's going on. So someone's got to open it. Same with the IRS, though. Those letters don't like to get opened, and it's not good. Now, interesting. 2 days ago, the IRS announced a little different program, right? So there's some things happening now with the IRS. First of all, it's part of the budget the last year or so. They're getting $80 billion to strengthen the IRS enforcement and processes and technology, which a lot of it is actually good, but they're coming for you. Okay, so that part's not necessarily good. And what happened was during the pandemic, back in 2020, the IRS, they took the reins off them as far as like trying to send collection letters and garnish and levy people because the whole pandemic was crazy. So some people may have got their first letter, but they weren't getting follow-ups. And now with the IRS, you got a lot of interest and payments and penalties and that kind of stuff. So starting in January, starting in a couple of weeks, they're going to start pounding away on collections. So people are starting getting, people and companies are starting getting IRS notices. The training wheels are off. The pandemic stuff is over, and they're coming hard. Okay. Now what's going to happen is you may have got a letter 3 years ago, you owe 10 grand. They weren't giving you the updated notices. Now it's 60 grand, something like. So it's going to be kind of shocking. So what they're doing is they're announcing that they're doing it. They're coming for you. Okay. But they're also going to give you a little break. So if it's like 2020 and 2021 taxes, they're going to abate the penalties on those. So try to help you out. And, they think there's like 4.7 million is what they were saying, individuals and businesses that didn't get these notices and can maybe get $1 billion in relief. Now, besides the taxes and payments, there's what they call failure to file penalties also. So the IRS, they're always a little tricky in their language and stuff like that because they're going to abate certain things, but your failure to file penalties are not automatically abated. Though they're talking about, I was reading this 2 days ago when they announced it. I still have to go through it more. Trying to help with that too, but that's not the automatic one. So the point is they're coming for you. You're going to get a big notice. Some of those could be lowered again, but you're still going to have the big bill. And whatever, even though it's lower than they're talking about with the penalties and abatements, they're back to the enforcement. They have $80 billion behind them. They've hired more people, more collection people, and they're going to start placing liens, levies, coming for assets. And you really should lawyer up with a tax lawyer and get that resolved. Because at the end of the day, they're coming. But the mandate on the IRS is still to resolve taxes reasonably whenever possible. And that's one thing people don't always understand because, first of all, they don't open the letter. And if they do, it's not always so friendly or even in English. Sometimes, how it's read, it says it's intent to levy, but it's really not a final intent. It's all kinds of confusing things. But the bottom line is, if you contact a professional like myself, there's others like me, we could contact the IRS. There's a power of attorney we would get to resolve your tax issue. There's different power of attorneys. One is to represent you, one is just to get information. But the IRS likes to have someone, a lawyer, a CPA, or what they call an enrolled agent, to help you out, because they want to get paid. Now, just because you owe X dollars doesn't mean it's all collectible, right? But if the IRS is sending you a letter, a little love note, and you're not responding, they have no idea if you got money or don't. So they're just coming, right? So what you do is there's tax resolution options. For the most of them are like offer and compromise, installment agreements, what they call currently not collectible, which means they'll put you on hold. Phew, people don't need to do that. There's also first-time penalty abatements besides this program for other tax years, because the program I'm talking about now is only for those 2 years, not because those are the pandemic post years, not the ones before 2020. So those you still got to try to get abated or lowered, and all that kind of stuff. So it gets complicated. So now an offer and compromise is basically reducing the amount owed and payable, maybe 6 months to 72 months. But it's not automatic. It's not a magic negotiation. It's an exercise in cash flows, assets, liabilities, cash, and there's exemptions for that. There's IRS standards, similar to bankruptcy, right? So what is the collectability over X time, right? And if you show the financials and show what you have, they're going to accept it, right? And depending on the debt, like it's 50 grand or less, sometimes you don't have to even prove documentation. The higher debt you have, the more documentation you have to get. And they have what's also called partial pay plans. An installment agreement is basically a monthly payment plan, but then they have what they call partial pay installments, where you're paying part of it. It's similar to Chapter 13, and just paying it in full or not. So there's different programs depending on the dollar amount owed, the threshold, and then we analyze you, again, just like in bankruptcy, if we were talking to you, what program or programs do you qualify for? What's the pros and cons of each? And what can we go for? Because everybody wants us out. I mean, to settle cheap, right? Well, okay, so you got an offer and compromise, but just because you submit it doesn't mean it's going to be accepted. So you need a professional to say, what are our chances of getting this accepted, and at what number? Because not one of these national radio shows saying, oh, we settle for pennies on the dollar, all that BS, right? It's not a magic conversation where I'm a lawyer and they don't, we just settle the debt. It's a formula of cash flows, and it's like being a lawyer on trial presenting your case to the IRS. Here's the liability, here's the formula, here's the Internal Revenue Manual, here's why you should accept it. At the same time, what would the government get in an installment agreement? Now, in an offer and compromise, they may get paid quicker. So they look at that as well. And then, of course, an installment agreement, though, that could be years down the road, compared to maybe an offer, maybe getting paid in maybe 1 month or maybe 6 months, sometimes a little longer too. But what's the difference? I'm getting 10 grand in the offer and compromise. I'm getting 100 grand in the installment agreement. They may want the installment agreement. I'm getting 10 grand in the offer and compromise. I'm getting 15 in the installment agreement. They may take the offer and compromise, because it's called the bird in the hand, right? It's like, hey, it's only a couple of $1,000 difference, but now we're done. Because in an installment agreement, yeah, you're getting that down, the government's getting it down the road if you pay. Now, you fell behind the first time, that's why we're talking to the IRS, right? Saying it's just like, it's like, the chance of falling behind again, something happening, cost of monitoring the program. So all those things get calculated into there, and we'll help you determine. We try to analyze it the way the IRS would analyze it. So we know, hey, something, offer and compromise is going to work, or, maybe even though the installment agreement's a little higher, in this case, the offer may work, or this is the formula so different, it's not worth trying the offer because they're not going to take it. maybe go for partial pay installment, or on your situation currently not collectible. Let's talk about the penalty abatements if we can, or talk about bankruptcy. I mean, if again, we analyze you for everything. Are those taxes dischargeable? And if so, when? So if I could discharge them, maybe you want to file. I had some guy call me just last week. I may have talked about some other show. It was 40 grand, but now it's 140. They owe, but it's like 8 or 10 different tax years. So he may want to file, depending on how much we can get rid of, just to get rid of it, and if he qualifies. But the point is, as I told him, it's my job is to give you the options anyway. You know what I'm saying? So I'll analyze them for you and give you the options. Let's figure out, are you getting rid of all of it or some of it? And if it's only some of it, then maybe you're getting rid of that. And then we're doing, offer or something else with the IRS on that as well, but on a smaller amount to make it a manageable payment. So there's all kinds of different formulas, but open those letters and then call me or call me and I'll open them for you.
Well, you know what,
the office.
Kevin?
And because the point is the IRS, they will work with you through a professional. I mean, they can work with you directly too. I mean, you can do it yourself if you want to take them on. But also, if you do it yourself, you know what you're doing, and you may be saying the wrong thing, and you may trigger some things you don't know. But the point is, get a professional, and they want to resolve it with you. So, for example, you hire me or someone like me. Let's contact the IRS. Let's say, hey, here's a power of attorney. We just got retained. Can we get a temporary hold on collections, hold on levy, hold on liens, Can we get a hold? Let me get into this game here, analyze it, Mr. IRS agent, and then we'll submit, the documents to you or our plan, and we'll go from there. And they're happy to do that a lot of times, So, and then also, as we're doing that, you may have a hardship where it's like, something, I don't need an offer. I don't need a installment agreement. I just need a currently not collectible. You got a hardship, and trying to collect on you, if you can't eat or causing some stress and hardships, they will just put it on hold. But now you're in their system on hold, not being levied, not being garnished, not being attacked. Now, a couple of years later, we may have to resolve it, but at least you got peace of mind knowing you're okay, because the IRS is a tough collection agency. I mean, as a bankruptcy lawyer, we deal with collections all the time. IRS is tough, and they got a lot of tools.
Yeah. Why should a person not speak to the IRS themselves and hire somebody like yourself?
Same thing as somebody being pro se in a litigation case or pro se bankruptcy, or a lawyer doing his own case. It's not smart. First of all, you don't know what you're doing, because there's a reason not everyone, you could do it yourself, but if it's not you, it's got to be a CPA, attorney, or what they call an enrolled agent. An enrolled agent is someone who's not a lawyer, not a CPA, but they took certain courses and they got a enrolled agent license, so they're an enrolled agent with the IRS. So the IRS knows they know what they're doing, okay? Because the IRS is not going to let any Tom, Dick, and Harry just start doing things. You got to be professional. So, and there's a reason for that, because you got to know what you're doing. How are you doing the cash flow analysis and the assets, and how do you know when to argue and when to not? How do you know when to take it to the appeals, collection due process hearing, go to U.S. tax court? I'm a tax lawyer. I'm also licensed in the U.S. tax court. EAs, CPAs, a lot of lawyers aren't in tax court. So depending on how the situation or how far you can be going the appeals, they can't even go all the way with you. With me, I can go all the way with you. All the appeals hearing, the audits. If I have to go to tax court, let's go to tax court. I'm saying we will defend you, and we operate like we're lawyers, because we are. I'm saying? So you're presenting a case to the IRS. I mean, so if I'm in, state court or federal court or BK court doing a trial, you're presenting your case. I'm in tax court. I'm just presenting my tax case. I'm saying, or defending it. So it's the same thing. There's discovery in regular litigation, and there's somewhat of discovery with the IRS as well as documents, stuff like that. So there's a whole appeal process in the litigation. It's appeal process with the IRS. So it's just like being a lawyer in court, only it's a little smoother if you know what you're doing. So no, you shouldn't really. Plus, you don't know what you're going to say. You get nervous. You say the wrong thing. You may make them think you got something. Now they're saying no and investigating you, or who knows what's going to happen. It's just a whole ball of wax. I mean, you owe $3,000-$4,000. Yeah. I mean, you call them because you get an installment agreement or make an offer. What's going to happen? But if you owe that little and it's not dischargeable, you just file Chapter 13 and pay it over 60 months, no interest. So what's the difference on that as well? So it's just a matter of resolving it either way, whether it's offer and compromise, installment agreement, non-collectible, or of each of those programs, there's sub-programs, offer and compromise, doubt as to collectability, offer and compromise, doubt as to liability. You owe $50,000, you owe $100,000, you owe $200,000, you need documents, you do not. How are you going to know that if you're just a regular person? Or can I discharge it in bankruptcy? How do you know you're not a lawyer? So it's a mistake.
Well, the IRS is very scary. But what I love about what you do, Kevin, is once they sign up with you, they don't have to talk to the IRS anymore. Exactly.
That's the whole point. So you get a tax resolution person or tax lawyer or CPA or enrolled agent. You sign the power of attorney. We step into the shoes and as the power of attorney, we show it to you. I mean, it's certain tax years for certain things. It's not a power of attorney to, turn the plug out in the hospital or take over your finances or anything like that. It's simply to talk to the IRS as your representative, as your tax lawyer for these specific tax years on these 1040s, whatever kind of tax problem it is. Sometimes we make it a little bit general. Sometimes we add a couple of years to the power of attorney, because maybe as we're doing something for you, maybe it takes a while. And now here comes the next tax year. And if that power of attorney doesn't have that tax year on it, I can't discuss it with the IRS on there. So we just may add a couple on there just in case as we're doing it and the next tax year pops up, we could just talk to them instead of having to do the paperwork. But absolutely, it's the power of attorney. And that's one of the biggest things with hiring a professional. It's scary. I mean, public speaking and IRS, death and taxes. I mean, that's the most scariest thing people say. Let someone do it for you. Saying if you're being sued, you're going to get a lawyer, right? Let them talk for you. Get a professional, get the collection hold, and the stress is just so many people. It's unbelievable. The expression is the face, is the relief that people have that, hey, it's being worked on. And of course, now the client's still working with me. You got to cooperate with me still, and still give me stuff and
right
as we analyze. But people are happy to do it. You know what I'm saying? So, well, most people. Some people still, go away. But yeah, it's a big sigh of relief. Same thing in bankruptcy. You're being hounded by creditors, foreclosed, sued. Mm-hmm. Oh, I just filed. People I could have done this years ago. Because it's like boom, it's easy. It's like not this big thing like on TV where you're destitute or something like that. Same thing at the IRS. It's like, hey, I owe taxes. Maybe you don't. Maybe it's, had your CPA get the return done again. Who knows what, or sometimes it could be criminal. We handle that as well. But it's just a financial matter, criminal matters aside, it's a financial matter to resolve with the IRS, and they're happy to do it. And having a professional expedites that. And the IRS is mandated basically to, try to resolve these issues. Doesn't matter if you owe $100,000. You can't pay it back, but we got to show them. You can't just say, I'm going to file bankruptcy. Well, is it dischargeable or not? Or, I'm going to just take 10%. You got to show them. It's some work, but they will cooperate.
Kevin, you have a lot of tools in your tool bag, don't you?
Yeah, thank you. Actually, I think we have more tools than most people, not just being a lawyer, but being in the tax court. And I have a lot of experience in bankruptcy, so that comes in very handy. That's how I got into all these things. I used to do a lot of bankruptcy, and people got tax issues. That may not have been why they filed, right? But okay, now you're out of debt. And the IRS maybe did a Chapter 7, which goes about 4 to 5 months. And the IRS will send you a letter. Okay, while you're in bankruptcy, we're back off. But then 4 or 5 months later, discharge order comes, they get notified, boom. So now, of course, we resolve a lot of debt for you, right? But now you got the IRS on your back. So now we could, resolve that for you. So we started doing taxes that way, resolving IRS issues. And then sometimes we didn't have to because we learned how to discharge them in bankruptcy if you could, then you're done. You know what I'm saying? So, there's a lot of tools. I mean, I can't think of anybody who's got more tools than not just a tax lawyer, but a tax lawyer with a bankruptcy background and is also a member of the U.S. Tax Court. Just saying.
I want people to know that by hiring you, that they're going to feel the biggest weight off their shoulders.
Yeah. The IRS is scary, but there's nothing really to be scared of. Open the letters, give them to me. Let us send our power of attorney in. It's like sending a representation letter in for them. I know where they. So basically, first we'll do a transcript analysis, right? What are on the tax transcripts? What does the IRS see? What can I see on the tax transcripts? Are they, going to lien you, or are they about to, or where are we on the stage? Because the client oftentimes doesn't know because they're not opening the letters. They don't know what's going on. So we got to do our research, and we see, okay, what is the situation, right? Like being a lawyer, what are the facts, right? Give me the file, give me the evidence, right? So then what tax years are issued, and are you compliant? Have you filed? Maybe some of the years haven't filed yet, or maybe the IRS filed what they call the SFR, substitute for return, and they're not doing you any favors when they file that. They're not taking any deductions for you. You know what I'm saying? So maybe they filed that, so they've said it's 10 grand, but that's only on their estimate. Now you file the real return, and then maybe you don't owe anything. It could be easy, or you owe less. So that's one way to do it. Or if they didn't file that, they don't know, so they're estimating. I mean, even in bankruptcy, some people haven't filed. IRS files a claim, estimating X amount. And my client's like, "What?" I'm like, "You got to file returns." So investigation, tax transcript, compliance, right? If you have certain years, and I don't do the tax return, but I can help you get a CPA or accountant or work with yours, and you file your returns. So now we're compliant. And then once we're compliant, now, of course, I'm working on all the other stuff as well. I'm not going to submit the offer in compromise or the installment agreement or anything else until we're compliant, because the IRS wants you compliant. But now we got you compliant, boom, and then boom, submit the offer or installment agreement or partial pay or wherever we are and start negotiating. Or maybe it gets accepted, who knows? So it's really a 3-step process. And then, of course, the third is the resolution. So now we submitted it. If they don't take it, now we're negotiating, or maybe they're turning it down. Now we got to go to appeals or tax court, or maybe even during the process, the revenue officer or revenue agent, maybe they're not complying with the Internal Revenue Manual, and maybe I think they're not, shouldn't be doing that, right? So maybe we got to go over their head to their manager. There's the whole process over their head, which is different than the other appeal stuff. So, and that's something you wouldn't know if you're doing it yourself as well. You got to know the Internal Revenue Manual, how to find things, how to do it. But it's really a 3-step process: investigation, compliance, resolution, negotiation, resolve it one way or the other. And you'd be surprised. It will get resolved. It will. That's
the bottom line.
Yeah.
Kevin, let's give everybody your phone number and your website again.
Phone number is 312-853-3100, benjaminlaw.com, 312-853-3100. Or you can email us at attorneys@benjaminlaw.com, or just go to the website, benjaminlaw.com, or give me a call, 312-853-3100.
You're amazing. You're amazing. Kevin is with us every month. He'll be back again with us next month, and we'll be talking more tax relief and bankruptcy. Kevin, have a wonderful, wonderful Christmas. We'll see you soon.
Thank you. Thanks, Steve. Bye-bye.
That's attorney Kevin Benjamin. Well, he knows the IRS, and he knows, let me.
It's Kevin Benjamin. And I got to tell you, we've been having technical problems all evening, so I do apologize for that. We're going to get it taken care of. We'll see you all next week with more Ask the Experts. Get your questions ready. And thank you for giving us 50 minutes of your time. We know time is precious. Have a Merry Christmas. God bless everybody. We'll see you soon.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.